This video is for entertainment purposes only. We are not experts, professionals, or certified authorities on the subject matter we're about to discuss. Everything we say here is based on our personal opinions, experiences, and research.
Yo, what's going on?
Sure. All right. I think that leaves us then with Miss Monroe on behalf of the DA's office as well.
Yes, good afternoon.
The Fulton County Attorney. Okay.
Okay, so thank you, Judge, for putting this case on your motion calendar on such late notice. So the reason for our motion to quash is, number one, these documents that were requested have been provided to the defendant's counsel by way of the Fulton County portal.
All right, let's go into specifics. I'm looking at a copy of Exhibit A of the subpoena. It's got 7 bullets. Which of those are you contending have already been provided?
So it is I don't know this specifically, but it's our understanding that about a majority of the responses have been provided and viewed by defendant's counsel. And if not provided directly through the portal, it has been attached to the various motions as supporting documentation in this case.
Yo, what's going on? So that is Fani Willis's team, her counsel, talking to the judge, telling the judge that yes, everything on the list has been provided, and we have nothing more to give you guys, right? Just to lay it out like that, because as you see on the thumbnail, there's 2 invoices, 20-some, 27, 20. I don't know. You'll listen on. You'll hear that are missing, and you'll find out who has it, because they snitch on her, right? They kind of snitch on her, but because they ain't got it, right? Even the records lady ain't got it. But let's go.
And also readily available by public information.
Which ones haven't been, though? Because that could still be relevant for the subpoena.
I don't have that direct information, but in light of the responses that have not been provided, there is no relevance for the information. We have a criminal case. The things that they're asking for there's no connection, there is no relevance, and the defendant admits that there's no reason in which these documents there was no reason provided as to why these documents were requested. And in order for a subpoena to be issued in this fashion, there needs to be a material reason for the subpoena. And in this case, we do not have one.
Okay, Ms. Merchant, what haven't you gotten that was on Exhibit A, and why is it relevant?
Yes, Judge. So I have not gotten all of the invoices for Mr. Wade. I started asking for those back in September through the open records, and I got some of them piecemeal. I got a couple others that the state attached to their motion. So the open records officer said I had gotten everything, and then the state attached a couple more. So now I have even more, but there's still a couple that are outstanding. So there's several that are outstanding, and we put that in a very detailed pleading and letter to the Fulton County County Attorney. We have not received a single invoice for Mr. Bradley. We do not have a current contract for Anna Cross or John Floyd. And the issue with that is that Ms. Willis made statements that she paid them the same amount of money. The contracts we have for Mr. Floyd, that is an incorrect statement. He was not paid the same amount of money. We do not have either current contracts for either of those folks. We don't have anything about
missing contracts.
We don't have anything about the reimbursements for Ms. Willis, and we don't have anything in regards to the last bullet point.
What makes you think that travel reimbursements because everything seemed to be personal travel?
No, well, Judge, that's
Oh, just real quick, cause I want to make sure y'all stay in tune on this, cause there's a lot of other discrepancies. Even one of her Fani Willis's representatives, Cross, they're missing her invoices. And she's in court representing her, and they can't get the invoices for her. She says they don't exist. She says they don't exist. They asked her. So just listen on.
We're not sure that it's all personal travel, and I don't believe that it is. This is all evidence that is related to us showing that Ms. Willis had a personal and a financial interest in this prosecution. Reimbursements for her travel. We have some reimbursements for Mr. Wade's travel. So are those trips connected? Those were the things that we're seeking. We sought all of these through open records. These are open records, but the county has been refusing to give them to us despite way longer than 3 days. So before this hearing was set, we already were in litigation over the open records violation. These are things we're entitled to. We don't have to show that they're relevant in the open records context.
Sure.
But so then we get a hearing, and instead of waiting for the litigation and them to actually give us the documents to the open records, I have to get them in through a business certificate. So I can't submit an open records. So I cannot submit all of these invoices. These invoices are hearsay. I need a business record certificate. I sent a subpoena to the county asking for a business record certificate. They have to certify the documents they've already given me. Plus, they've got to give me the documents that they haven't given me.
Okay. Let's keep making our way down the list. I can see your argument on travel and vacation, since that's at the core of your allegations. The last one, though, talking about all hiring and outside counsel, that seems to go more towards what I'd indicated has a lot less relevance for me.
Hiring an outside counsel for...
Just generally, it says any outside counsel, process for hiring bids, payment of outside counsel.
Are you talking about, and I just want to make sure...
The final bullet, any and all correspondence.
Oh, okay, I understand. I want to make sure, because I printed theirs out right before I left the office. This is in regards to a Board of County Commissioners meeting that was held in November 2023. There was a very detailed conversation between Dexter Bonds and I can't remember her name, but she's the purchasing director for Fulton County. They had a very detailed discussion and said that there had been a problem with the processing of invoices with the district attorney, and that they had to talk with her and go through a new rebidding training with them, because essentially they were having services that weren't going through the proper channels. We believe that these documents are relevant to show the personal financial interest of the district attorney.
How so?
Getting things paid for without approval.
Okay, so that's going more towards the approval aspect of it, and the, maybe county, what you would refer to as, impropriety and sticking to county regs. Is that fair?
Not necessarily county regs, but also sticking to the statute, which is the basis for all of this. The statute that was not followed, which is the basis. But also, what are these? Is she having a personal financial benefit to this prosecution by submitting invoices and things like that?
I just want to add and just provide further clarification. It's our understanding that pursuant to the subpoena and the information that's being requested there in our possession, Fulton County Attorney's Office, all of that information has been provided. But in terms of the open requests that were submitted, the separate open requests that were submitted to the district attorney's office on a separate open records request, we wouldn't have personal knowledge as to what requests have been fulfilled or not. But in terms of what we have in possession in our office, we have that information has been provided already by the district attorney's office. So there's nothing outstanding pursuant to this subpoena that we would have that they don't have access to already.
Okay, so just to be...
I don't have anything authenticated. I haven't received one single authentication from them.
And I think that's what it comes down to. She's seeking authentication. We just want to make sure that we are fulfilling our end. And if this is information that she has already received by abusing the legal process with subpoenas just to obtain authentication, is not a proper use of the legal system, nor is it coupled with the fact there is a pending litigation, as Ms. Merchant so emphasize pending against the district attorney's office regarding an alleged Open Records Act violation.
Well, how else would she authenticate it then, Ms. Monroe? Were you planning to come down and have someone personally testify to it?
Without a subpoena?
I'm sorry, I didn't hear the question.
Well, I mean, more to the point, it seems this conversation.
The judge asked her, like, how else is she supposed to authenticate the document? So if they are talking about the invoices, or if she has them and they're just not authenticated, I believe it's just hearsay. It's like the court's not going to accept it as like factual evidence.
Keeps shifting. It's either the county attorney does not have the items requested, or is the sole issue now just authentication of the items that she already has, the defense already has?
Your Honor, may I be permitted to speak? This is Shalonda Miller. I am the designated records custodian for Fulton County. Okay. And I might be able to provide some clarification. Individuals request open records. We are not required to authenticate responses to open records requests. That's not a part of the Open Records Act. We're also not required to produce anything that we do not have in our possession, even when individuals think we do. I'll give an example there, Ms. Murphy.
No, I agree with you. I don't need an example. But I guess all that would remain then is what Ms. Merchant is saying, that if all she's after is authentication and that hasn't been provided, but she thinks that a witness she has
never
subpoenaed.
Requested authentication, Your Honor, absent the subpoena.
All
that
right.
wasn't a request. The first time we saw anything about authentication was at the service of the subpoena.
Okay. All right. So, Ms. Merchant, where does this stand then?
Judge, two things. First, that's how we have to get business record certificates, is we have to subpoena the witness, and if they want to avoid coming and testifying, they can submit a business records affidavit. We drew one up and submitted it with the subpoena. So I believe we followed the proper procedure to get these records certified. As far as that they've given us everything they have not. As far as the first bullet point, we do not have invoice number 22 or 25. It's not been attached to anybody's pleadings. It's not anywhere, any place.
Okay.
What's in invoice 22 or 25? We just want to see it now. What's in the invoices? They're missing. Who has them? Come on, let's get it.
Start there. So, Ms. Monroe, is invoice 22 or 25 something that's in the possession of Fulton County?
Not that we're aware of, Your Honor.
Who would typically retain custody of those kind of things, those invoices or reimbursement requests? Would that just stay with the district attorney, or would Fulton County have all that?
And just a little research, Shalonda Miller, the records lady, I don't know her official title, she actually ran to be a Georgia judge, the 5th Superior Court, all right, in the Atlanta circuit in 2022, so 2 years ago. So this is a judge. She better not be in here lying. That's all I'm saying.
The district attorney, and we'll follow up with our client, but it's our understanding that they've provided the records they do have. I'm not sure why and R25 would not be a part of those records, but we can confirm that all that we have in our possession has been provided.
And Judge, I've been asking for invoice 22 since September.
Okay. All right. And Ms. Merchant, you were talking about, you said that the next 3 bullets were invoices for Mr. Bradley, contracts for Ms. Cross and Mr. Floyd. I guess turning to Ms. Monroe or Ms. Miller, are those also things that you're saying are not in the possession of Fulton County and only in the possession of the district attorney?
We're not trying to delineate between the district attorney and Fulton County. What we're saying is our clients provide us those records, the records that they have in their possession. There are presumptions about what should exist and what we should have in our possession, but just because individuals think they exist doesn't mean we necessarily have them in our possession for whatever reason.
Okay, understood. Do you have them though?
No, not that we're aware of. And we have conferred with.
No, not that we are aware of. She don't know. But she pretty much just told on Fani Willis talking about our client. When you start bringing in the client, when the judge starts asking tough questions, I think you kind of led them to where the documents are. Let's go.
With our client, and it is our understanding that everything that is in the client's possession has been provided.
Okay, so then that sounds like a follow-up question to their.
She's a judge. She just pretty much said like, hey, you need to kind of ask if you want these documents. Our client has the documents. I mean, I don't know. This is more than any reason to have her subpoena not quashed. Right? She pretty much said her clients has given everything. So if we're not aware of anything else, according to our client, in so many words, that's pretty much what she said. We got everything.
The client, the district attorney's office, if they've been under subpoena for these same documents. But for now, the person subpoenaed is saying, or the entity subpoenaed is saying they don't have them. And unless counsel has a reason to show that they do, I think that's usually the end of it.
Ms. Cross appeared today, I believe, under contract. She's been submitting invoices, so I mean, maybe they just come and testify as to how they have people under contract.
It's not that it doesn't exist. It's where is it, and have you subpoenaed the right entity or person?
Well, they have represented that they represent the district attorney. They even filed this motion to quash saying they represented the district attorney. So
that's a very good point. So, Ms. Miller, Ms. Monroe, regardless of whether they're down the hall or across the street, if you are the entity where legal process has to go in order to serve the district attorney's office for production, how does that get you out of complying with the subpoena?
Your Honor, I'm so sorry. I don't mean to interrupt, and you can tell me to wait, and I will gladly do it. But insofar as we're talking about a subsequent contract for me, there is none in existence.
Okay.
No contract in existence for her. She's just there for free, I guess.
And that's again, I keep hearing two different things. Either it exists or it doesn't exist, or someone has or doesn't have it. And then we keep flipping back and forth between the two, and I'm trying to nail this down.
Apologies, Your Honor, for being unclear. Anything that we have in our possession, that our client has in its possession, we have provided.
Okay.
There are assumptions about things that we have that are inaccurate, because we've provided everything that either our office or the district attorney's office has.
Okay.
We're not trying to hide anything.
No, that makes it clearer. So that you're saying that you would be, either you or collectively the DA's office would be responsible for providing these if you have them. And your understanding, just again going back to the first bullet point, is that a invoice 22 or 25 has already been provided.
It may not have been provided, Your Honor, but if it hasn't been provided, it's because we don't have it in our possession. And when I say we, I'm saying a collective we, the district attorney's office.
Okay. Thank you. I think that's where I've been getting held up. Okay, but that's something you plan to follow up and confirm.
We will definitely follow up we have followed up numerous times with our client, but we will again for the purposes of the court here.
All right, fair enough. And as for the remaining items, contracts with Floyd, Cross, Bradley, is it the same thing that collectively you either think they've been provided or they don't exist?
Correct.
All right. Ms. Merchant?
We would just ask that they come for, obviously they can't do a business record certificate to say something doesn't exist. So I think it just makes sense then for me to not even ask for the business record certificate and ask them to just bring the certified documents, whatever they have, and testify on the 15th of August. Seems the only way to figure out what exists, doesn't exist, existed. Invoice 22 has been paid. Invoice 25 has been paid.
Sure.
So someone has them.
Okay, so I think ultimately it's if there is something that you are being compelled to provide that does not exist or that has already been provided and you can confirm that, then there's no obligation on your part to do anything further with the subpoena. However, it appears that in order to complete the evidentiary record, counsel needs at least some kind of testimony establishing the absence of a record, or testimony authenticating records that have already been produced. And so if there's not going to be a certification to that effect, then there would need to be live testimony to that end. And so I don't think that an outright quashal is what happens with this motion or Fulton County.
Understood, Your Honor.
If there are other particulars that come up between now and Thursday, and you think you want more guidance or clarification, we can take it up.
Thank you.
Okay.
Thank you.
All right. Thank you all
May
for
we be
joining us.
excused, Your Honor?
Of course. Thank you.
Thank you.
Thank
Have
you.
a good afternoon.
All right. Are there any other? I think we got through them all. Anything else? Anyone else here who anticipated needing to address the court? Ms. Cross, anything else?
Just a minor logistical point, Your Honor.
Yes, ma'am.
At any evidentiary hearing on Thursday, we would ask the court's permission to have a witness who's out of state testify remotely.
All right. Can you identify that witness?
Yes, it's the district attorney's father. His name is Mr. Floyd. He's in California.
All right, Ms. Merchant, is that something you're prepared to address at the moment?
If I can speak with him ahead of time, then I'm very likely to agree and not object to that, and waive the notice that we're permitted.
All right.
But I just asked that I be allowed to speak to him.
Okay, and Ms. Cross, is that solely for logistical reasons, or are there other, perhaps, medical concerns or other things that might compel remote testimony?
There are medical conditions, as I'm aware, none that affect the witness's ability to appear, but I believe there are some medical issues involved in addition to the out-of-state travel.
Okay, understood. I'll let you and Ms. Merchant take that up, and you can let me know if that's something we still need to address before Thursday. As I mentioned, we've set aside all day Thursday. We've also set aside Friday, and we'll see if further time is required depending on where the hearing takes us. In terms of logistics, I know a number of defense counsel have adopted the motion and joined it. Many of them are with us today. Ms. Merchant, have you had any conversations with counsel as to how you would proceed? Are they all planning to have you as their flag bearer? Or are they all, when it comes to arguments, when it comes to direct or cross-examination?
I haven't had that specific question. I think that I'm probably going to be leading it, but I'm not sure. They filed a little bit different motions. Some of them had some different allegations, so they may have their own issues. As far as that, I did have one housekeeping matter, though. Mr. Wade has not accepted service of our subpoena. The state raised that in their motion. Since he has a lawyer, I reached out to Mr. Evans, his lawyer, and asked him if he would accept it on his behalf. I didn't want my process server to have to follow him around. I hate having lawyers do that, but I just need some direction if he's going to accept the subpoena or if I need to have him staked out. So there's an alternative means of service, is there not? You can serve as counsel of record? Yes, I can serve it. Well, in civil I can. They raised an objection in Ms. Cross's motion to the service that I'd sent by certified mail, and he keeps refusing that service. So the alternative would be for me to either serve his attorney with permission of his attorney, Mr. Evans, or...
I don't even know if it requires his permission. I don't have the statute handy at the moment. Maybe someone else can pull it up, but it's about 2 code sections following quashal. So 24, 13, 25, if you can pull that for me.
I mean, if he's accepting service, then it would obviously be easy, but I don't know if he is.
But what I'm curious about here is if it matters whether his attorney is accepting or if you just send it to a certified address, if that's sufficient.
The law says if we send it certified, that is sufficient. I know that the statute, I actually did print that statute out. He's refusing service, though. So I'd think that they could raise that because they raised it in their brief. They're raising that it wasn't.
Well, if the lead counsel in this case is refusing service, I'll entertain a motion for a continuance.
Thank you, Judge.
Your Honor, before we go, can I correct something?
Sure.
I misspoke when I said that Mr. Floyd had medical problems that might prevent his travel. That's not the case. It's just his location in California that would require the remote participation with the court's permission.
All right, thank you, Ms. Cross. Anything else, Ms. Merchant, you said is housekeeping?
Mr. Gillen said he is going to be presenting a summary witness, but that's it as far as other, just for housekeeping. A summary witness, hopefully to summarize all of the financial.
Yeah. So interesting here at the end, you're gonna hear.
All right, so again, I would ask you to.
Donald Trump's counsel actually asked for an ex parte conversation with the judge off the record after the court. So wonder we'll hear what that's about later on.
To confer with counsel to confirm whether everyone's expecting to do their own argument. If so, we're going to have some time limits. If other people are presenting their own witnesses, I haven't heard of any because I haven't gotten any other motions to quash. And whether folks are combining their ability to cross. I think if they've joined the motion, they have the right to present their own evidence. I think I can limit argument to some extent. And again, I can very much, as we get through cross, if a question's already been asked, I don't really care who's asked it. And we'll streamline things that way. I think someone from the gallery wanted to be heard.
Yes, from the gallery, Your Honor.
If you could identify yourself for the record.
Yes, Steve Sadow, counsel for President Trump. When you're finished, I have a unrelated matter I'd like to take up with the court outside everyone else's involvement.
And is this ex parte?
It would be ex parte, yes, sir.
All right. Anything else? If not, we'll be off the record. Thank you.
All right, so you heard it there. If y'all want to check out the full hearing, just go. It's online YouTube. Go look for it. It's about an hour long. But there's a lot of other stuff on it, especially about the witnesses and pretty much how the Star Witness, the Star Witness, they got a Star Witness that regardless whatever these people say, he knows the truth and he has a conversation with these people about it, so they know something. So like you'll hear through the hearing, they use the term impeach. He'll build it. Like if he said he don't know anything, oh yeah, this dude can he knows something. He's been in conversation with them. So apparently the Star Witness is in a circle with Fani Willis and a bunch of other attorneys that could testify to this whatever's going on right now with Fani Willis and her unethical relationship, I guess. And I'm not sure to what extent, because it seems like it can grow. It can definitely grow. Like there's definitely stuff that they haven't showed all the evidence. They haven't even provided all the evidence. So with that said, I'm gonna let y'all go. Like, subscribe, comment, all that. Thank you.